All right, it's 4:30, and we'll get our presentation moving. Oh, there's Dawn. Okay. All right, so first of all, I'm Karen Title. I'm a professor in economics and accounting, and I want to take this opportunity to welcome you to Ream Library today, and also take the opportunity to introduce the program. This is the first major event of our program called the Minor in Ethics, Society, and Institution of Business. It's a relatively new program at the college. It's an interdisciplinary minor through which students take a distinctively liberal arts approach to studying the institution of business, the practices that define it, and the many ways that it impacts our society and our world. We thank the McFarland Center and the National Endowment for the Humanities for supporting our efforts and our talk today. And I'm going to turn over to Professor Denise Schaefer to introduce our speaker.
Hi, everyone. Good afternoon. Yeah, there's a few seats on the side if people want to look for extra seats. Great. Well, thank you all for being here on this snowy day. I'd like to echo Professor Title in thanking NEH and Tom Landy and the McFarland Center. And I'd like to add a special shout out to Ruby Francis and Sarah Potter, whose work made this event possible, as well as to our AV team for setting us up and recording. And now it's my pleasure to introduce our speaker. Ann Lipton is the Michael M. Fleishman Associate Professor of Business Law and Entrepreneurship at Tulane University Law School and the Tulane University Murphy Institute. She's also the law school's Associate Dean for Faculty Research. After receiving her JD from Harvard Law School, Lipton clerked for U.S. Supreme Court Justice David Souter and Third U.S. Circuit Court of Appeals Judge Edward Becker. She then worked in securities and corporate litigation at the trial and appellate levels at law firms in New York City, where she handled class action lawsuits involving some of the world's largest companies. She also worked briefly at the Securities and Exchange Commission. In 2015, Lipton joined the Tulane Law faculty. As a scholar, she explores corporate governance, the relationship between corporations and investors, and the role of corporations in society. Her articles have appeared in the Journal of Corporation Law, Yale Journal on Regulation, Georgetown Law Journal, and many others. In 2020, one of her articles was named one of the Corporate Practice Commentators list 10 best articles of the year. She blogs regularly for Business Law Prof blog and is a frequent expert commentator for various media outlets. I don't think she sleeps, actually. So we're absolutely delighted to have her here with us today. So please join me in welcoming Professor Ann Lipton.
Thank you. Thank you for that kind introduction, and thank you for so much for inviting me to speak today and to showing up through the snow and making it here. Professor Schaefer has told me all about the Ethics in Society and Institution of Business program, and I'm really grateful to have the opportunity to talk to you and to hear your questions as well. So, for whom are corporate managers trustees? That question was famously asked by a law professor, Merrick Dodd, in the Harvard Law Review in 1932. It was the title of an essay he published, arguing that businessmen, all men in those days, who ran America's corporations should consider themselves trustees of the public generally, and not just for shareholders alone. Business corporations, obviously, they make money by selling goods and services, but in order to provide those goods and services, they incur expenses. They have to buy raw materials, they have to pay wages, sometimes they might even pay taxes. Any money they have left over, that is profit. Profits are what the shareholders can claim. Corporations can increase their profits if they increase their revenues by raising prices or selling more goods, and they can increase their profits by minimizing expenses. So the argument Dodd made in 1932 was when corporate managers make decisions about how to increase profits, or by increasing their revenues or minimizing expenses, should they only consider the interests of shareholders, or should they consider the interests of society at large? The essay was one half of a debate with another author who argued that corporate powers are held in trust solely to benefit shareholders. That's how far back this argument goes, at least. It's the oldest argument in corporate law. Today, the argument has taken on a new life in the concept of ESG, which is the subject of my talk. But before I get to where we are now, I want to talk about where we've been. So let's look back in time to the history that led up to that debate in 1932. And we start by asking, what is a corporation? The answer is, a corporation is a legal entity, by which I mean a corporation doesn't exist in nature. It's not found in the shape of a flower or the beat of a hummingbird's wing. It is a legal creation. Corporations are formed when their founders draft an organizing document known as a charter. The charter serves the same function as the US Constitution does for the American government. It explains the basic structure of how the corporation will be set up, how the board of directors will be selected, the board's powers, what kinds of shares of stock it will be issued, and the rights associated with those shares, that kind of thing. To create a corporation, the organizer submits the charter to an individual state, any state, Delaware or Massachusetts or Texas or California. The charter has to conform to that state's rules. Assuming it does, the organizer pays a fee. Don't forget the fee. The fee is very important. Pays a fee, and voila, the state declares a corporation has been born. Corporations, as legal creations, have a few common features. They are recognized in the eyes of the law as independent entities, distinct from their shareholders and distinct from their employees. That's really important because it means a corporation, this creation of law, can own things. It can own land, bank accounts, patents, office furniture, just like a person. It can sign contracts just like a person, and the corporation can be held liable on those contracts. It can bring lawsuits and be a defendant in a lawsuit, just like a person. Corporations even have some constitutional rights, not all of them, but they do have First Amendment free speech rights. That said, corporations are not in fact people, and we know that because they can live forever, as long as the state chooses to recognize them. Corporations also have a very important feature known as limited liability. What that means is shareholders in a corporation are not responsible for the corporation's debts. If I own stock in IBM and IBM suddenly can't pay its bills, no one knocks on my door looking for me to pay up. These characteristics probably seem obvious, they seem natural, but in fact, the corporate form is a relatively recent innovation. Before the invention of the corporation, most businesses were general partnerships. The partnership wasn't an entity in its own right. It was just a group of people who were working together. The people who formed the partnership, the general partners, they jointly owned all partnership property. They were individually liable for business debts. That meant if the firm failed, all the partners could be liable for that money. Creditors could seize their homes, their land, their personal heirlooms, all that could go. That's not how corporations work. Because corporations are recognized as independent legal entities, the owners, the shareholders, are not responsible for the corporation's debts, even if the corporation doesn't have enough money to pay them. Which means, in practical effect, shareholders get to claim the profits of corporate activity, but if the corporation can't pay the bills, it's the people who are owed money, employees, lenders, customers, who are stuck with the loss. These features of the corporate form are so powerful and so valuable that originally, and when I say originally, I mean America's founding originally, they weren't available to just anyone. When states chartered business corporations, it was usually for public works or infrastructure, like a dam or a bridge or a canal. Corporate charters were heavily negotiated by the state legislature, and the charter would lay out in meticulous detail exactly what the corporation was formed to do and the limits on its powers. The charter would say, this corporation was organized to build a toll road from point A to point B and charge exactly these prices, that kind of thing. The corporation couldn't engage in any activity that wasn't explicitly laid out in the charter, and the board of directors would often include state representatives. We could look at these early corporations as a kind of public-private partnership or even an early form of administrative agency. And to ensure the corporations didn't get too big for their britches, the charter might contain limits on their power. It was common to require that the corporation dissolve after 10 years. Corporations might only be able to raise some maximum amount of capital. They weren't permitted to hold shares in other corporations. In this era, we're talking late 1700s, early 1800s, the charter itself was how states regulated corporations. Each corporation was permitted to exist only by a special act of the state legislature, was chartered for a particular public purpose, and its powers were limited to the actions that were necessary to accomplish that purpose. But over time, the system came under stress. The main objection was democratic. Only well-connected people with friends in the state legislature got to form a corporation, and the public demanded that the privilege of doing business in the corporate form be made available generally. So that's what legislatures did. Throughout the 19th century, states made corporate charters available for any business, but the charters were still very restrictive, with different rules for different industries, because the grant of a charter with all of these limits on what you could and couldn't do, that was how states went about regulating local economic activity. But the economy expanded. America got bigger. Technological innovations made it easier to do business across state lines. And the more the corporation's business activity extended beyond the chartering state, the less interest the chartering state had in regulating corporate activity. To put it another way, if I get my charter in Delaware, but I do all of my business in Massachusetts, Delaware doesn't care what prices I charge in Massachusetts. Only Massachusetts cares about what prices I charge in Massachusetts. So states started to limit their corporate law to become far less restrictive. Now, corporations were permitted to raise substantial amounts of capital. They didn't have to dissolve after 10 years. They could hold shares in other corporations, which allowed the creation of holding companies that controlled multiple businesses. Mergers became easier so corporations could grow in size. Charters weren't granted for just a specific type of business. Now they'd say any legal business was permitted, which meant a single corporation could evolve to adjust to changing times. What remained in the charter were only bare-bones structural requirements, like corporations are managed by a board of directors and the board is elected by the shareholders. That's still true today. But all of these rules that were intended to protect creditors and consumers and the local economy, all of that was moved out of the grant of the charter, out of corporate law, and into a brand new body of regulatory law. We got antitrust law to protect markets, and labor and employment law to protect employees, and food and drug and regulation, product safety regulation, environmental regulation. These new regulations came partly from the federal government, but also from state governments. Except now the states regulated anyone who did business within their territory, regardless of who granted them the charter. In the late 1800s then, corporations were freed of the chartering restraints. That meant they could grow to enormous sizes. Whole industries consolidated, leading to the giant monopolistic corporations of the 19th and early 20th centuries. Limited liability meant that far-flung investors were willing to buy corporate shares because they were confident they wouldn't later be held liable for business debts of a company that they had no real control over. After World War I, we saw a huge influx of retail investing. Retail investing means ordinary people. Retail investors poured their money into the stock market after World War I, and what has been called a great shift of corporate finance from the investment houses of Wall Street to Main Street. These new patterns of ownership were very different from what came before. Now, there was a huge distance between the individuals who supplied capital to corporations, these dispersed ordinary people from all over the country, and the corporate leaders who actually ran the companies on a day-to-day basis. And it was that shift in the organization of the corporate form in the nation's economic architecture that prompted the question, should these captains of industry, princes of property is what FDR called them in 1932, should these princes of property who exercise so much power over the daily lives of ordinary Americans, should they manage their corporations solely to benefit the shareholders, or should they instead manage the corporations for the benefit of society as a whole? And we've been having the same argument ever since. On one side of the debate, you have the advocates for what is known as shareholder primacy. Shareholder primacy generally means that corporate managers, officers, and directors have a fiduciary duty to run the company solely in the interests of shareholders. They are legally required to maximize profits. Now, there are obvious dangers to that system. Remember, states don't limit corporate sizes anymore. When they grant a charter, that means corporations can accumulate unimaginable material resources. They coordinate the activity of thousands of people. The largest corporations control more wealth than many governments, all under the direction of a very small group, the board of directors, exactly as state corporate law requires. That makes corporations and the managers who control them very powerful. And that power can be used for good. It can be used to build necessary infrastructure, to conduct critical research, to provide great works of art and the fundamental necessities of life. But corporate power can also be abused. Corporations may destroy our environment. They may produce goods that are shoddy or dangerous. They may mistreat their employees or form monopolies that stifle innovation. So if they're run solely to maximize profits, don't we run the risk that corporations will inflict tremendous harm? Yes, says the shareholder primacy, that absolutely is a risk. But the way we address that risk is regulation. We pass laws that make it illegal to dump pollutants. We pass minimum wage laws, workplace safety laws, environmental laws. That way, if corporations break the law, it'll cost them. It will eat into their profits. They will not perform well for their investors. And it's not just law that's doing the work here. We have markets too. Consumers won't buy products that are defective or dangerous. They'll buy from a competing firm. Employees will quit if you don't treat them well or pay them generously. Or to put it another way, it might be cheaper to make planes that fall out of the sky, but pretty soon customers aren't going to get on Boeing airplanes. So it's actually better for your profits if you actually just, put the bolts in the door. In the end, government regulation, coupled with the invisible hand of a market that reflects popular sentiment, will make it unprofitable for businesses to behave in an antisocial manner. Corporate managers don't have to think big thoughts about society. They focus on profit. But society will arrange its institutions so that profit can only be achieved by pro-social actions. The interests of shareholders and the interests of society will become aligned. That's one side of the debate. But then there's the other side, which is, it doesn't work. It's not good enough. That's not good enough to protect the public. Think about how you live your life as a person. You don't do the bare minimum of complying with the law and then behave completely selfishly in every other respect. You do more. You go beyond the bare minimum. You give to charity. Not because you want a tax deduction, but because you have sympathy for people who are in need. You let someone in a hurry cut ahead of you in line. You leave a tip for your server in a restaurant, even if you don't expect to eat there again. It's simply not possible to legislate every single form of good behavior we want to encourage. At some point, you just have to trust people want to do good. But a corporation acting under a rule of shareholder primacy, it doesn't get to tip the server. Under shareholder primacy, corporate managers are legally required not to leave money on the table for the server or anyone else. Sure, the corporation can make charitable donations, but only if they expect good publicity. It can pay employees well, but only if they otherwise think that competing firms will steal them away. Or to put it another way, there is something very wrong with a system that says Boeing is legally required to make planes that fall out of the sky right up until the point where customers won't get on them anymore, and if the government thinks that's too many planes, it can regulate harder. Of course, defenders of shareholder primacy have a response to that, though, and their response is, if corporate managers are expected to operate with a degree of social conscience, if we're asking them to sacrifice profits, other people's money, in order to further some moral value, whose values do they pick? Do we expect corporate chiefs to magnanimously dole out corporate wealth, shareholder wealth, according to their own values? Do we want Mark Zuckerberg making decisions about which social goods to prioritize? Henry Ford was personally praised by Adolf Hitler. Do we want him making social policy? To put it concretely, Elon Musk is right now managing Twitter, former Twitter, according to his personal values. He took over the company, and his conception of free speech means that a lot of openly white nationalist accounts are permitted to post there and may even be amplified if they pay for a subscription. This is, from a business financial point of view, an objectively terrible decision. It's cost him advertisers, it's cost him users. Financial analysts agree that Twitter has lost more than 2/3 of its value since he took it over because the advertisers all went away and he hasn't replaced the revenue. And that's because Musk cares more about his vision of the social good than earning profits. But Musk isn't the only investor in Twitter. Even now, it has other shareholders. For example, Fidelity has a mutual fund, the Blue Chip Growth Fund. Ordinary people invest in the Blue Chip Growth Fund, and that fund has shares in Elon Musk's Twitter. So that means anyone who's invested in this Fidelity fund, all these ordinary people, they are all indirectly bearing the costs of Musk's free speech policy. So this is what the world looks like when you say corporate managers should sacrifice profits to further the social good. Corporate managers then get to decide what the good is. So shareholder primicists say, we live in a democracy. Elected governments should decide our social policy. Governments should decide to limit fossil fuel usage to protect against climate change. It's not on Ford Motor Company to just stop selling gas-powered cars even if people still want to buy them. Corporate boards simply don't have the legitimacy to make those decisions using resources that were contributed to the corporation for business purposes. But wait, says the stakeholderist, as I take both sides of this, if corporate managers are obligated to do everything they can to maximize shareholder wealth, the first thing they're going to do is lobby to change the law. They're going to use all that wealth and all that power they have amassed in order to persuade politicians to minimize regulations that are intended to protect the public. They will employ armies of lawyers to find loopholes to exploit. They're going to avoid paying taxes and leave government regulators underfunded. They will pick up and move operations from a well-regulated jurisdiction to an under-regulated one. They will not only do that, they are required to do that because under shareholder primacy, they are required to work to undermine the very legal rules that are supposed to place guardrails on their behavior if that will maximize profits. Just a couple of weeks ago, the New York Times reported that Apple Computer keeps getting sued for patent infringement. And it got tired of losing these cases in court, so now it's going to Washington to weaken the patent laws. Because of course it is. That's what shareholder primacy is. That's how it works. And this is true for markets as well. Remember, corporate behavior is supposed to be constrained by the public directly. If corporations behave badly, consumers won't deal with them and employees won't work with them. But a profit-maximizing corporation has to try to loosen labor laws so that employees can't form unions and can't bargain. A profit-maximizing corporation must try to loosen antitrust laws so that consumers don't have choices. It's just weird to have this system where one corner of the law sets up these regulations to protect employees, the environment, consumers, and another corner of the law says, you, corporation, which the state chartered, your legal obligation is to undermine those regulations as much as possible. We shall by actual legal command require you to do so. So that's the debate. It's been going on for over a century. Everyone knows the dance. But there is a way out. There's an exit. Shareholder primacy requires that corporations be run for their shareholders. Fine. What does that even mean? Up until now, we've been assuming that shareholders want to maximize their profits, but it's not like anyone asked them. A lot of shareholders are employees. Maybe they'll accept fewer profits if it means higher wages or more medical benefits. Shareholders are consumers. Maybe they'll accept lower profits for cheaper products. Shareholders live on this planet. They might accept lower profits if it means avoiding the ravages of climate change. Shareholders are human beings, and they may just care ethically about making the world a better place. Of course, the way shareholders are supposed to express this view is democracy. If that's what shareholders want, they should vote for it in political elections. But if corporations have the power to make society less democratic, then maybe the answer is we need more democracy in our corporations. After all, corporate democracy doesn't have gerrymandering. It doesn't have complicated voter registration requirements. Any shareholder can vote. It does have nonpartisan election administration. In the political system, it's legal to lie to voters. In the corporate system, we call that securities fraud. So let the shareholders decide. I mean, it's not really democracy. Democracy would mean giving labor a vote, giving consumers a vote. We're just talking about giving capital a vote, but it's something anyway, and this has been not a particularly new idea. It's been proposed almost as long as this argument's been going on. Ever since the early 1900s, when shareholding became widespread, there have been movements to enlist shareholders to get them to exert democratic discipline over their portfolio companies. In the 1940s, employee shareholders agitated for more labor-friendly policies. In the 1950s, women shareholders demanded female representation on corporate boards. In 1951, Bayard Rustin and James Peck, famous civil rights activists, bought shares in Greyhound bus lines so they could attend the shareholder meeting and propose a vote on whether to desegregate the buses. In 1969, shareholders of Dow Chemical tried to organize a movement to vote against the production of napalm for use in the Vietnam War. In 1970, Ralph Nader spearheaded what was known as Campaign GM to get the shareholders of General Motors to vote to restructure the board to emphasize social responsibility. None of these attempts were successful. And at least one reason why: people have lives, and they're not paying that much attention. We can barely get people to vote in political elections. Do we seriously expect them to vote in corporate ones? But beginning in around the 1980s, something changed. If the 1920s saw a movement towards widespread retail investing, the 1980s saw a de-retailization of the shareholder base. Pension funds became huge shareholders. Pensions are trust funds that promise employees and union members that they'll have a guaranteed income when they retire. And the trust buys shares in corporations so that it has enough money to be able to pay the benefits later. Beginning in the 1970s, a number of changes were made to pension law that encouraged a massive shift towards investment in corporate stock. Even more than that, we saw the growth of the mutual fund industry. Huge shell entities that hold hundreds of stock, a mutual fund. Individuals buy shares in the entity, and thereby they get exposure to a diversified portfolio because the entity is holding a whole bunch of different stocks. But the fund is managed by a mutual fund company, and a single mutual fund company may oversee hundreds of funds, which means a single mutual fund company decides which shares to buy and sell and how to vote them. Mutual funds have exploded in popularity, in part because of changes to the tax code and changes to the regulation of retirement plans, and that makes them an attractive option for employers that want to provide retirement benefits to employees. Mutual funds dominate the market. BlackRock, Vanguard, and State Street, those are the biggest three sponsors of mutual funds. Collectively, through the ownership of the funds they control, they're the largest shareholder in over 40% of all US publicly traded companies. Just those three. But here's the thing about these institutional investors. They are legal constructions, just like corporations are, and they are highly regulated. They are required to cast votes. They can't just ignore votes the way individual investors can. And now this idea, this project of getting shareholders to exercise more control over corporate conduct can actually work. And that's because the shareholders aren't human at all. Enter ESG. What is ESG? ESG stands for Environmental Social Governance, and the phrase refers to a particular approach to investing and to managing a company. The theory is investors, and therefore corporate boards, should attend to how their business affects and is affected by the environment, how their business affects and is affected by human relationships with employees, customers, communities, and should attend to some notion of good corporate governance, transparency to investors and the public, protections against self-dealing, giving investors a voice in corporate affairs, that kind of thing. Investors may choose to invest in companies that score highly on ESG metrics, or they may cast their vote to express a preference that managers adopt ESG policies to mitigate the environmental impact of their actions, improve working conditions, that kind of thing. But wait, investors aren't human. They're institutions. They're the titans of Wall Street. If these institutions try to force corporations to sacrifice profits to effectuate social policy, we're back to the Henry Ford problem. Managers of mutual fund companies don't have any more legitimacy than corporate CEOs, which is precisely why institutional investors are subject to a host of regulations that either require or at least strongly encourage them to maximize the value of the fund without regard to other concerns. For example, pension fund trustees required to act solely in the financial interests of the pension fund, not the beneficiaries. Most people who hold shares in mutual funds have them through a retirement plan, a 401k plan. And the way that works is your employer gives you a limited selection of funds to choose from, and you can direct that a portion of your salary is invested in those funds so that you have that money when you retire. Under federal law, for the most part, the funds that are included in the menu that your employer provides must be selected based on financial performance. Employers are not allowed to include the sacrifice some profits in the name of protecting the environment fund. That fund can't be on the list. It's not an option for you to pick. Which means any mutual fund company that wants a slice of the retirement business, which is pretty much all of them, must focus their funds on maximizing wealth. The point goes further. Let's say you want to invest in pro-social companies as a person, or there are actually a few small asset managers that do this. They focus on values. Now we have another problem. How do you know which companies those are? Well, the way we generally know about companies is through the federal securities laws. Every company that's publicly traded, meaning its stock is generally available for people to buy, every one of those has to make regular disclosures about its business. It discloses its finances, its strategies, the trends that are affecting it, and so forth. Those disclosures are mandated by the Securities and Exchange Commission, the SEC. But the SEC only requires disclosure of matters that are of financial concern to investors. That's the scope of its mandate. It can't require disclosure of bad social behavior if it's not financially relevant, which means shareholders, institutional or otherwise, may not even be able to distinguish good social actors from bad ones. So it's hard to ask shareholders to sacrifice profits in order to further some social goal. So we need a new argument. And what is that argument? ESG is a financial concern. Doing good will, in fact, maximize profits. This isn't charity. This isn't shareholders generously sharing profits with other groups. In fact, pro-social behavior does pay off, at least in the long term. For example, climate change. Governments around the world are requiring that companies reduce their carbon emissions, and investors may, purely as a financial matter, want to know that their portfolio companies are going to be able to comply with those rules cost effectively. You could say the same thing about social factors. If companies mistreat their employees, they'll have high turnover, they'll have labor unrest, and that will also cut to profits. And this is, in fact, where the idea for ESG comes from. ESG was initially proposed by the United Nations as a way to persuade the largest financial institutions in the world that a globalized economy requires minimum standards of conduct to avoid backlash and hostility to industrial development. Now, let's be clear, the UN was not doing this out of some urgent concern for the capital class. It wanted to protect local populations who were injured by corporate activities. At the time, the UN was focused on things like exploitation of labor in the developing world, corruption of local officials, destruction of natural resources, that kind of thing. But earlier efforts to appeal to shareholders' moral sense had failed, so the UN adopted a new tactic, enlightened self-interest. Good behavior will open up new profitable markets and bad behavior will close them off, and that idea spread among financial institutions and was built outward. So even though ESG is discussed publicly as a moral approach to investing, that's actually not how it's talked about in the financial world. This idea that we should evaluate a corporation's social performance in order to protect its profit-making potential, that's not at odds with shareholder primacy. It's the underpinning of shareholder primacy. It's necessary for shareholder primacy. Because remember, the theory of shareholder primacy, CEOs should only worry about profit, and society, regulators, markets, decide what kind of activities are and are not profitable. The entire justification for shareholder primacy, the entire reason anyone says it's okay for CEOs to run these massive corporations only concerned about shareholder wealth, is that we assume society has arranged institutions so that profits can't be achieved through antisocial behavior. That power is, in fact, being regulated. If that's right, if that's how we set the system up, then absolutely, investors should care about pro-social behavior. It's a predictor of profit. We want pro-social behavior to be a predictor of profit. That's how we know the system works. But now we're right back where we started. We began this whole exercise by arguing that the regulatory system is not sufficient to align profit-seeking with the social good. If that's right, then a focus on financial ESG will not, in fact, turn corporations into better social actors. We can go back to climate change. It is certainly reasonable for companies to develop a transition plan if they anticipate new regulations. And it is completely unnecessary if they can lobby those regulations out of existence. It is reasonable for companies to develop good reputations with consumers and employees, but they may be able to do that with a press release rather than changes to substantive behavior, which is what we call greenwashing. What all this means is we've come full circle. An idea for plugging regulatory gaps in a shareholder primacy system ends up just buttressing it. The way I put it is ESG is an attempt to change corporate behavior without changing anything about corporate structure or corporate law. But here's the thing. As you all know, ESG has become something of a political football. Politicians accuse large shareholders and the companies that respond to them of wasting money. They accuse these giant financial institutions of pursuing a social agenda instead of pursuing profits. I promise you, the financial institutions who support ESG, they say it's financial. They believe that preparing for climate change is a financial concern. They say diversity is a financial concern. And yet politicians object to ESG anyway, even if the actual institutional investors swear they're only considering financial factors. So what is going on? Well, now we have a dispute over what is and isn't financial. Recently, the SEC adopted new disclosure requirements. The SEC is requiring that public companies disclose more about their relationship with their workforce. There are disclosure requirements about board diversity. The SEC is requiring that public companies disclose more about carbon emissions and their vulnerability to climate change. Why? The SEC says these are financial concerns. Companies have to disclose. Investors have to know which properties are going to be underwater in 10 years or, under a foot of snow in April. And guess what? Politicians are accusing the SEC of overstepping its mandate, of trying to advance a social mission instead of a financial one. The SEC's climate change rules just came out, and there are already like half a dozen lawsuits trying to block them, all based on politicians insisting that climate change is not a financial concern. Mississippi and Tennessee are currently suing BlackRock, the largest asset manager in the world, and they claim that BlackRock is violating its fiduciary duties to the investors in its mutual funds because it supports efforts to mitigate climate change. Politicians in Mississippi and Tennessee insist that BlackRock is pursuing a non-financial goal with its investors' money. And that's only the tip of the iceberg. All over the country, politicians are proposing new regulations for large institutional investors, pension funds, and mutual funds. They want to limit the kinds of facts that institutional investors can consider when investing in their portfolio companies, and the argument always is these new regulations are necessary to keep institutional investors focused on financial returns. So we'll talk about Disney. Florida announced a parental rights bill that prohibited discussion of sexual identity in schools. Disney's CEO, Bob Chapek, initially announced that the company was not going to be taking a position on the bill. He wanted to stay out of politics. Florida-based employees were furious. They opposed the bill, and they wanted Disney to use its political influence to block it. They began staging protests and walkouts. The company became ungovernable. It was a public relations nightmare. So Chapek did the absolute least he could do. After the bill was passed, when it was already sure to become law, that's when he declared Disney's opposition. The gesture was so hollow that the Human Rights Campaign initially refused Disney's accompanying $5 million donation. In any other context, we'd call that greenwashing. From a corporate law perspective, this is what shareholder primacy looks like. The company felt in real time pressure on its ability to generate a profit, and it reacted. If the workers had demanded a raise, maybe that's what he would have given them, but they weren't. They wanted a political statement, and the company gave them the bare minimum it could to buy labor peace, which is exactly what a Delaware court would later hold when a shareholder accused Disney of abandoning business motives and pursuing a political agenda. But it did not work out very well for Disney. Ron DeSantis, the governor of Florida, stripped it of special privileges, which was potentially pretty damaging to the company financially. And what happened after that? Disney was just embroiled in a massively expensive proxy fight, meaning a challenger sought board seats and tried to displace the current board of directors. The challenger went around campaigning to Disney shareholders, these large institutional investors, trying to persuade them that Disney's current board was not maximizing profits. There were a lot of different arguments they had, some which have nothing to do with this, but one argument was Disney is getting too political. It stepped into the culture wars. The challenger explicitly said Disney was focusing too much on movies with all black and all women casts, and new board members were needed to right the ship. That vote was yesterday. Disney won. So this exercise has taught us something about shareholder primacy, a design flaw, if you will. If you believe shareholder primacy is working, if it's functioning as expected, then absolutely, pro-sociality has to mean profit. But that just means shareholders making investment decisions have to gauge what is and isn't pro-social, which puts them right back in the political thicket we were trying to avoid in the first place. This is the problem shareholder primacy was intended to solve. Anyway, I'm not a politician. I'm just a business law professor. Here's how I see things. At bottom, what's profitable is what's popular. Companies make money by appealing to popular tastes. Maybe they're selling a product. Target sells clothes for non-binary customers. Disney makes movies with a mostly black cast. These companies earn a profit if there are enough customers to buy the product. Sometimes it's not about selling a product, but it's about creating an image that corporate managers think will make the company popular. Investors have demanded that companies pay more attention to diversity. They want diverse boards, diverse workforces, and companies have also insisted that this is a high priority for them. And honestly, I'm not going to say diversity initiatives are a bad thing. I think they're a great thing, but the evidence that they make companies more profitable is ambiguous. And you don't really see companies committing to these initiatives all that much. They hire diversity officers and then the position turns over because there are no resources devoted to it and there are no clear goals, so they quit. So why are investors asking for this and why are companies doing it? I mean, political activists will say these companies are pushing their own social agenda. They've gone woke. I personally find that very hard to believe. We'd see more commitment to diversity from big companies if they were actually pursuing a social agenda. I think it's far more likely these diversity initiatives are public relations. This is what greenwashing looks like. These companies think that it's popular, and therefore profitable, to at least create the appearance of being committed to diversity. Fine, whatever. But right now, at this moment, we are in the midst of some fairly heated cultural battles. This country is being torn apart over fights about who gets to represent the culture, who gets to represent the mainstream. We're fighting over whose view of the culture is the most popular. And that makes it very easy for profitability to be viewed as a kind of proxy for popularity. And if profitability is a proxy for popularity, that means profitability is a proxy for political legitimacy. If diversity is profitable, even as a public relations campaign, that tells us something about how America sees itself. If selling trans merchandise is profitable, that tells us something about the role of trans people in American life. So as we fight over what's popular, that fight necessarily spills over into a fight about what's profitable. And that ends up into a fight about how profit-seeking investors should allocate their investment dollars. And because profit-seeking investors are large institutions that are regulated by law, now politicians get to weigh in on what they actually think is popular and therefore profitable as a business strategy. And that's capitalism. So my point, and I do have one, is this. We think of corporations as private enterprise, but it's not that simple. States have always decided the structure of the corporate form. States decide the role of shareholders within the corporation and the responsibilities of the board. The government decides whether and how to encourage investment in the stock market. The government regulates the information available to shareholders and the factors that giant asset managers are permitted to consider when making investment decisions. If you want to create more socially responsible corporations, if that is the idea, it's never going to be as simple as moving one lever like encouraging ESG and considerations because we're looking at a system. It's a web of legal rules that construct the corporation itself. And you can't get at those rules while avoiding politics. This is fundamentally a debate about how power is allocated and exercised in our society, and that's not an apolitical question. It will always be political. But that doesn't mean change can't happen because corporations are legal entities, and law is a function of what all of us collectively decide it should be. And thank you. And now I'd love to hear if you have any questions.
Yeah, we have, Professor Lipton's going to field her own questions. If you're right up front, you might be able to speak without the mic, but speak loudly enough so that people behind you can hear. But in general, if people want to go to the mic, that would be useful, I think.
Yeah.
Is there a particular case scenario or experience that you had that drove you into being kind of interested or passionate about this particularly?
Yeah, law school. When I actually went to law school with the intention of becoming a civil rights lawyer. I like to tell other law students that because I like to say, like, boy, did I do a 180. I went into civil rights law and ended up doing business law. In my so I planned to go to do civil rights law, and my first year of law school, I learned more about corporate power and the economic rules that sort of structure our system. And I was thinking, you know, I really want to do that. And so that's what I ended up going into. And when I graduated law school, I wasn't a professor. I wanted to practice, but my practice was suing big companies. That's what I did. I sued companies for securities fraud. Yeah.
think of the argument that now that that's gone, corporations and schools are going to say, well, actually we need to be creative about how we bring in diversity into our corporation or our school. Do you think that that will make, I guess, ESG like more of a topic?
Yeah, well, see, it's really complicated right now because in part because the same forces that like led to that case are now suing corporations a lot, which makes, my understanding is that they're like, trying to figure out what the line is to walk about diversity. Although apparently, literally a study came out today that said, if you look at the public SEC filings that these public corporations have to file, they're still talking about diversity and they're giving details on the diversity of their workforce, so they're still paying attention. But I think corporations are like heat-seeking missiles for profit. We've built them that way. We didn't have to build them that way. There are other ways you could imagine building them. In Germany, for example, workers get to vote for corporate boards and alongside shareholders, but that's not the system here. There are options. But right now, America has kind of constructed corporations as profit-seeking missiles, which means I don't think they're going to do anything for diversity unless they actually see the profit case. They'll say they are. And the profit case may very well simply be people like us more if we have a diverse, board. I mean, that could be the profit case, but they're going to have to see what it is, I think, and that's really the only thing that's going to happen. So now then they have to figure out how to, navigate that in a world where obviously, it's illegal to discriminate against any group, and there are a lot of law firms now looking to sue for any hint that they might be violating that law. So, but at the end of the day, corporations are profit-seeking missiles. If they perceive the business case for it, they will do it. Schools, of course, that's a completely different sort of scenario. Yeah.
If someone was interested in starting a corporation today, how would you tell them to start it?
Like the actual mechanics of it? Or
Just in a way that would be respect all the ESG values and
yeah. Well, the thing is that if you want, at the end of the day, you can do what you want with your corporation as long as your shareholders agree. Which means one way is to get a bunch of shareholders who all share your values. Okay, so this is actually a big issue in, there's a new type of corporation, these sort of social responsibility corporations that are trying to have both a profit motive as well as a values motive. And the idea is that they're being formed specifically to try to balance that. And their big concern is mission drift. So it's fine as long as you have two shareholders who completely and totally agree on everything. But once you need to raise money, and you start to have mission drift when you raise money from people who don't share exactly that set of values. And at the end of the day, it's not just about like whether managers' fiduciary duties to shareholders. At the end of the day, who has the purse strings can control the direction. So figuring out a way to balance to make sure that the purse strings are being held by someone who has a direction that you like is the trick. And that is, frankly, very difficult to do. As soon as you let control go to anybody who isn't you. So personally, maintain control while also getting people to give you money, which apparently means be Sam Altman. But otherwise, it's tough, and I don't really have advice so much as it is, there are a lot of people who are trying to invent different kinds of financial instruments, not just stock, bonds that have special features that will keep the corporation on mission while still supplying it with capital. Yeah.
Is it possible for a company to maximize profits and have good behavior in maximizing profits, or is it mostly the case that maximizing profits will lead to bad behavior?
I think it really depends on the behavior in the company and what it particularly is. I mean, let's talk, Disney, Black Panther was one of the, I don't even know what the numbers are, I'm not a Hollywood person, but we know Black Panther grossed, billions of dollars. It was nominated for Academy Awards, whatever. So, I mean, and so I think that was, a good thing in terms of advancing social values. So I don't think it's as easy as I think that corporations are sort of very dual natured. They produce wonderful things and they can do terrible things while producing them. Sometimes it's distributional. I mean, the iPhone is a fantastic innovation, but I don't think that all the workers all over the country are necessarily in the best positions when they make them. So, all over the world, sorry. So I don't think there's a clear answer to that. Depends on the company, depends on the pressures, and it's sort of incumbent upon society to figure out how to make those guardrails stick. Yeah. Yeah.
Do you think the benefit corporation structure is a valuable innovation in this?
No. And the reason is because it doesn't work very well. Okay, so the benefit corporation structure is that you found your company and you specifically say, okay, so the normal rule for a normal corporation is you have a fiduciary duty to the shareholders to maximize shareholder wealth. That's the usual rule. A benefit corporation, the fiduciary duty, you explicitly say you have a public purpose that you're supposed to advance in addition to shareholder wealth. That sounds good, but the way they're constructed now, there is literally no enforcement mechanism, absolutely none. The only enforcement mechanism that is the same one I said before. Give control to someone who you trust and don't let them let go of it. Well, you can do that in a regular corporation. There's no need for the benefit form to do that. I mean, at the end of the day, I don't think it doesn't do any legal work. Yeah.
What should the role of the state be in regulating sort of companies? So like, for example, you mentioned that previously Disney had special privileges in Florida and Governor Ron DeSantis revoked those privileges. Should it be the job of states to fashion these sort of laboratories of, maybe not laboratories of democracy, but laboratories of corporations? So if the corporation wanted to do social activism like Elon Musk's Twitter, and it does it and it fails spectacularly, then should a state allow another company to do the opposite thing and then make profit? Like, when should the state step in and when should it not step in?
I don't think it should step in for particular business decisions. I think what it should do, what the state has to do, states make corporations, it charters them, it's really about creating a set of rules that incentivizes the behavior we want to incentivize. And I don't think we have gotten that trick quite right yet. I think that we've structured, as I mentioned, what I truly believe is an actual contradiction, that we've structured corporations to seek profits however they possibly can, not just by saying you have fiduciary obligations, but by making sure only shareholders have voting power, and the shareholders are regulated by law, and the shareholders are required to seek profits. Like, it turtles all the way down. At every level, the corporation is designed to seek profits. And then we say, oh, but this other law should like constrain you. And I think that that's a weird system to have one legal rule that says, do everything you can to evade the law, and here's the law that's trying to constrain. And it's all coming from the government. Like, that's just weird. So I think we need to figure out a way to structure our corporations to provide better incentives or better governance structures. One thing that has a lot of people interested in, that periodically they're always interested in, it's sort of come to the surface again, Elizabeth Warren has proposed it, is giving employees a vote for corporate boards, just like they have in Germany. So it's not about giving permission to adopt a business model or not a business model. I mean, there's regulation, obviously, don't discriminate, those kinds of things. But it's really, I think, for me, as a business law professor, I'm thinking about how we can structure the corporation and the investors from the outset to channel them in more pro-social directions. Yeah.
Is there a current successful legal argument that a corporate executive has a fiduciary duty to anybody but the shareholders?
No.
So like there's never like not like.
Oh, well, okay, I'm overstating. Most publicly traded companies, most companies are chartered in Delaware. Remember, individual states charter, and you can pick whatever state you want. Delaware has been more than explicit that your sole duty is maximizing shareholder wealth. It could not be clearer. Now, there are other states that don't say that, but when you study corporations chartered in those states versus Delaware, they don't really behave all that differently because they have the same basic structure. Shareholders vote for the corporate managers, and the shareholders are institutions, and the institutions are required to seek shareholder wealth, and we're back here. It's more than any one rule. Yeah.
When you talk about these different things that go against one another being weird, I see that the most in healthcare because it's just been ridiculous that people are making profits and putting them ahead of what that is supposed to be doing. And it's just gotten worse and worse. And then in a company like Purdue Pharma with regards, how come, and well, excuse me, then another one in Boston, you have a whole slew of hospitals run by this steward.
Yeah, I saw in the private, and now the Senate is investigating private equity, takeover of nursing homes and so forth, yeah.
But it just seems ridiculous that that should be something that the fiduciary responsibility is to shareholders. And then, some of the things I've read about the steward, for example, that people didn't have any supplies, and how long does it take? Some of the regulation of people look at it, that's what seems so out of
Yeah, I think, I know that there's been some theorizing, a lot recently, theorizing that there are certain industries that are just different and shouldn't be part of the for-profit system, or at the very least shouldn't be part of a shareholder primacy system. Healthcare is one, defense manufacturing is another. I would say private prisons. Like, these are all things that, you know, one might think of as state functions that really shouldn't be private functions to begin with. But the other thing that I'd say about healthcare, and this is one of the things that interests me when I say we structured it all in a certain way, is that we've seen these horror stories about private equity. These are basically giant funds that are private, that are taking over like nursing facility, like nursing homes, things like that, and immediately running them for profit, much more profit than originally, so that there are more injuries reported, there are fewer staffing. I mean, all these kind of horrible problems. And there are all kinds of things that we can do in terms of healthcare regulations. But private equity, I mean, I can't draw a straight line, but private equity are big private funds. They are bigger today than they were 40 years ago. Why? The securities laws changed. That's what happened. In 1996, am I doing that math? 30 years ago. Okay, in 1996, the securities laws changed to make it easier to create giant funds. And look what those giant funds do. And those giant funds, who invest in them? Pension funds. They're allowed to. They're encouraged to. So there's no reason for that. That's law. So while there may very well be a case that certain kinds of industries should not be run for profit at all, schools, there is also, I think, an argument that at least some of these pressures are because of the way we've regulated our corporate law worlds that have, again, created profit-seeking missiles. Yeah.
Would you say that there's too much pressure on consumer influence for corporations like social responsibilities?
Well, I'm not really a business strategist, but I wouldn't say too much. I would never say too much by consumer pressure, and the reason is because I think I tend to agree. Like, I do have respect for markets, and I particularly consumer markets in the sense of consumers making choices is a lot like what democracy looks like. Now, the difference between consumers making choices and democracy is you got to have money to be a consumer, so that's not great because that means that people with more money will have an outsized representation. But it's something anyway. So I wouldn't say consumers have great, you know, too much is sort of the way I think about it. I think consumers should have influence over those kinds of decisions. Yeah.
What do you think about the ExxonMobil case where it sues two of its shareholders?
I know, isn't that hilarious?
Directly go against shareholder primacy?
I think it does. It's ludicrous. They're like, Exxon is so for those of you who don't know what this case is, under federal law, shareholders have the right to propose items for other shareholders to vote on at the shareholder meeting. So for example, I mentioned there was the attempt to get Greyhound bus lines to desegregate, things like that. And so a couple of shareholders try, and it's all federal law that gives them this right. A couple of shareholders tried to exercise this right to have a shareholder resolution that shareholders requesting Exxon to reduce carbon emissions in some way. And Exxon is suing now for essentially a legal declaration that they have no right to propose this and have other shareholders vote on it. And now imagine the legal idea you have to have of what a corporation is. It's a corporation, it's constructed by law, but it exists only for some shareholders, the ones that management pick. I mean, I don't even know how that's even coherent. I mean, they want a legal declaration that the only permissible legal interest is financial. These shareholders don't, and that's declaration 1. 2, these shareholders' interest is not financial. Therefore, 3, a court should decide that these shareholders should not be able to talk to other shareholders to vote on Exxon. I mean, it's just, really, for me, that just illustrates these are legal choices all the way down. Like, agree with them or disagree with them, but these are legal. This is not like the natural feature of the landscape. This is asking courts to decide which shareholders are allowed to have a say in corporations that they own a piece of. Have a court decide that. A court decide what the proper motive is. Which are the proper motives? Which are the right shareholders? You can agree with the argument or not, but like, just look at all the work law is doing. Yeah.
What court are they suing them in? Like,
They're all in Texas, all of them, every single one of these cases. Always. It's a federal court in Texas. Yeah.
In your opinion, so Citizens United, one of the things that it covered was corporate personhood. In your view, do corporations have any inherent rights?
Oh, I I don't know. I mean, I think it's complicated. I think there are certain kinds of First Amendment rights they have to have. Like, I mean, we have to be able to, like, I don't think it's okay that Ron DeSantis punished Disney for speaking out against his law. Like, that kind of First Amendment right, it's necessary. They have to be able to publish books and so forth. I mean, but it's still not the same as a natural person. And this is what Citizens United got wrong. Citizens United said, if shareholders don't like the way their money is being used, they can use the mechanisms of corporate democracy to change it. Well, the mechanisms of corporate democracy do not exist in the shape of a flower or the beat of a hummingbird's wing. We have Exxon suing its own shareholders to say, no, you may not use the mechanisms of corporate democracy to change how we spend our money. Citizens United just had this really simplistic view that the corporation is a collection of people, and those people can decide what to do with their money. And it's simply not like that. It's not people, it's institutions. There are laws restricting how they can interact with their own corporations. There are laws that restrict the kind of information they can even get out of their corporations in terms of political spending. It's just not the same thing as a collection of people getting together and deciding to contribute to a political campaign. Yeah.
So if we talk about changing corporate structure, corporate democracy, maybe the co-determination German type model, isn't there a danger that that stifles entrepreneurial change? And because often change that we do is computers or AI in the workplace, a lot of people get displaced. In other words, isn't that a structure that is going to focus people on the short term rather than the long term?
Well, I think it's really the opposite. I mean, right now, the concern is that shareholders are too short-term oriented. I mean, the fact is that, like, institutions, like their accounting, will only stretch out, 5 or 10 years or something like that. I mean, there's a lot of concerns that shareholders are very focused on quarterly returns, that they don't have enough insight into companies, let alone the business strategy, to be able to plan out 10 years. And that if companies were less responsive to shareholders, they would be able to focus on the long term. This is usually the justification for dual class shares. So there are all these companies where voting control is concentrated among a small number of people. And even though the economic control is with the great mass. So like Mark Zuckerberg has special high vote shares at Facebook. He only controls, like, I don't even know, 10% financially, but he has 60% of the votes because he decided to concentrate the votes for himself. And the argument there is this keeps us free of short-term pressures so we can develop for the long term. So the argument is usually the other way around, that shareholder control is short-termist. I don't know that I believe that. I don't think that it's obvious one way or another who's control or short-sighted. At the end of the day, every human, we have a limited amount of time, and we're only going to, we care about our lifetimes and our kids' lifetimes, but most people are not looking that far out. So I don't know that there's any one structure that is necessarily short or long-term. I think it's really about figuring out the structure that creates the best incentives. Thank you very much.